presence of our invited guests, especially in relation to Senate Bill number 1595, as we will be taking that up first.
Good morning, Mr. Chair. For Senate Bill number 1595, we have the following guests. From the Securities and Exchange Commission, we have Chairperson Teresita J. Herbosa. From the Insurance Commission, we have Attorney Denise Cabucos, Your Honor. For Senate Resolution number 468, we have from Bangko Sentral ng Pilipinas, Attorney Vincent Bolivar, Ms. Maria Belinda Caraan, Attorney Florabel Santos Madrid. From Luzon Development Bank, we have Mr. David G. Sarmiento. From the Anti-Money Laundering Council, we have Attorney Mel Georgie Birasela and Mr. Jerry Leal. And from the National Bureau of Investigation, we have Attorney Minerva Retanal. That's all, Your Honor.
Thank you. Let's take up House Bill number 1595 first while we're awaiting the authors of the resolution number 468, Senator Soto and Senator Lacson and Senator Poe. Senate Bill number 1595. May I request Chair Tess Herbosa to kindly walk us through as to the changes being proposed under this measure in broad strokes. Ma'am?
Thank you, Mr. Chairman. And good morning, everyone. As clearly put in the explanatory note, Your Honor, it's the proposed amendments seek primarily to align the provisions of the Securities Regulation Code with the standards set by the International Organization of Securities Commissions. This is the biggest organization of securities regulators in the world, and the purpose of which is to combat securities law violations, which these days have gone international or cross-border. And the primary purpose of the standards set by IOSCO is really to facilitate information sharing among securities regulators. And because of the nature of securities transactions, the most pertinent documents and records that could be used in the prosecution and investigation as well as conviction of securities law violators are actually bank records and documents. That is why the proposed amendments include giving SEC the power to directly access bank records and documents for the purpose of identifying and prosecuting those who violate securities law.
With the permission of Chair Boss, the Chair would like to acknowledge the presence of Senator Win Gatchalian. Good morning, sir.
Good morning.
You may proceed, ma'am.
Yes, and in addition to that, the proposed amendments would also give more enforcement powers to the SEC. In many of our experiences in the past, when we would like to go after investment scammers as well as people who use the stock market for market manipulation, insider trading, and fraudulent representations, we would always be stopped at that point where we have to determine who funded the alleged illegal activities. And it's that for that purpose that with the power to be able to access bank records by way of exception to the bank secrecy laws, the SEC can efficiently and more effectively prosecute and enforce laws against securities violations. And in addition, we would also want to join ASEAN initiatives which require that we become a signatory to the multilateral memorandum of understanding on information sharing with other securities regulators in the world. Without participation in the ASEAN initiatives, we cannot fulfill our national commitment to be part of the integrated ASEAN economic community. One of the initiatives concerns, for example, the trading of collective investment schemes, investments. And recently, the manual for such collective investment schemes trading or transactions was signed, but only by 3 countries in the ASEAN region, and not excluding the Philippines because of that impediment of not being a signatory to the MMOU. The failure to pass these proposed amendments, Your Honor, actually would cause some harm to the standing of the Philippines in the international financial community. This may result in some form of prohibitions or delays in the remittance of monies of OFWs, as well as loss of some relationships with foreign banks. And worst of all is that the Philippines may be perceived as a non-cooperative jurisdiction in the international or global efforts against transnational crimes such as money laundering and the like. So, if Your Honor, please, we would like to express our gratitude for your sponsorship of the bill, and we are ready to consider any comments, suggestions, or any statement that would help us refine or even improve these proposed amendments that we have for the Securities Regulation Code. Thank you, Mr. Chairman.
Ma'am, can you elaborate? Anong kinalaman nito sa remittances ng OFWs?
If
I
Your Honor,
understand
please.
there is a direct effect when we pass the AMLC amendments, but insofar as the SRC amendments are concerned, paano siya makakapekto?
It's because of the fact that the International Organization of Securities Commissions is an international body composed of all securities regulators and perceived to be as influential as the Financial Action Task Force, which is based in Paris. IOSA is actually based in Madrid. However, Your Honor, when it comes to the financial community in the world setting, they actually can influence also banks, because sometimes banks are the ones used for conduits of investment scams, and the banks usually go to either the IOSCO or FATF in order to be able to share information or to get information from countries where the money may have flown into. And they can actually adopt measures that would ostracize or even exclude Philippines from such flows of monies between and among countries.
A few points, ma'am. Number one, can you submit to us, not necessarily today, kung ano yung non-bargainable sa kanila? I'm sure you added some other things here that will help you perform your job better, but I'm sure also that there are some non-bargainable points. Kindly identify those in the bill. Second, ma'am, can you also submit to us which has been a policy of this committee, the cost of regulation insofar as the entities regulated is concerned? Whenever government wants to issue additional regulation, I'm sure it will entail some costs on the part of the persons or entities regulated. I do not know exactly how you can come up with that figure, but we would want at least an educated guess as to what it would cost the entities regulated if this law is passed. Example, ma'am, para hindi ho ako malabo. Nung pinasa namin o sinama namin sa version ng Senado yung provision sa train na nagre-require sa mga establishments na magkaroon nung makina na pwedeng malaman real-time ng BIR kung magkano yung sales nila, parang yun ang mga nasa establishment sa SM. Diba? Kasi ang SM, percentage of sales or fixed rent, whichever is higher. Real-time, nalalaman ng SM kung magkano. They now want to require establishments to have that. We objected to it because they seek to collect only 8 billion from them, and yet the establishments will spend, assuming there are 3 million of them, about 300 billion just to buy this equipment. Kung lahat sila talaga bibili. So clearly it's untenable. So the same is true here, ma'am. We would like to find out what the costs of these additional regulation will be insofar as the entities and persons regulated is concerned.
Yes, Your Honor, we can do that.
Thank you, ma'am. Third point, ma'am, on secrecy. So this is another bill that will, aside from the AMLAC version that we had originally, this is another bill that seeks to exempt itself from the coverage of the bank secrecy law?
Yes, Your Honor.
And I presume this is one of the provisions that is being required of us to have.
Precisely, Your Honor.
Any objections from the BSP? Asan yung taga-BSP? Yes, sir.
No, Your Honor. We support the proposed amendments, Your Honor. But we will be submitting our position paper this committee would require.
Yes, sir.
Thank you.
Kindly do so, especially on the secrecy exclusion or exception as proposed in the bill.
Thank you, Your Honor.
Next, does this bill address or touch in any way the usual conflict between the IC and the SEC? Naalala ko for the longest time, may away palagi ang IC at SEC with respect to securities, what the definition and coverage of securities is. Did this touch on it?
Actually, Your Honor, the definition of security under the Securities Regulation Code is admittedly quite broad compared to other laws in other countries. But it still has given us the proper parameters for being able to consider what are real securities and what are not. In fact, right now, Your Honor, the issue is whether bitcoins are securities. But that would always come into play, especially where we have a financial system that covers all those that would involve some form of financial transactions. We've had differences with the Insurance Commission only with respect to one aspect, which is the pending Collective Investment Schemes Bill,
Yes.
which is authored by the Honorable Congressman Salceda. And the portion of the insurance contract that would be considered as part of the pooled investments and therefore security is the variable contract,
We're not addressing that
which
here.
is addressed. No, it's not addressed here. It's properly really during the deliberations for the passage of that collective investment scheme bill.
That would be a separate law or an amendment to the SRC? The bill of Congressman Salceda.
No, the primary purpose of the bill is actually to rationalize the tax treatment of the different pooled investment schemes, such as the UITF of banks, the variable contracts of insurance companies, and the mutual funds of the SEC.
So in
As well
passing
as-
lang yun?
Yes, as well as the plan to have a provision that would put together all these pooled investments under the SEC, which the Insurance Commission has commented as not being acceptable to them.
So don't you want that addressed here? If that's a tax bill, it can better be addressed more directly. As you said, the definition of securities is quite broad under our law.
Yes, I understand and we sympathize with the fact that the variable contracts which are related to insurance policies have really given impetus to the insurance industry, and that it has helped more people to get life coverage because somehow it, I guess, makes the premiums payable for the insurance more acceptable and could be afforded by more people.
So you don't want to address it here yet?
In deference to the proponents of the collective investment schemes bill, because I think they've been working at it for the past 5 years, Your Honor.
May I get the comment first of Attorney Cabucos and then of Attorney Refran?
For the Insurance Commission, Your Honor, we'll be submitting our position paper on this on Senate Bill 1595. Now, with regard to the products regulated by the Insurance Commission, I think there's no legal issue insofar as the Insurance Commission as well as the SEC on this. All of our products that we are regulated are not considered as securities, and we are regulating that based on the law. Like, for example, the insurance code for insurance product as well as the printed code of the Philippines for printed products. On the case of the variable life, there is a provision in the insurance code expressly excluding that as a security. So I think the bill right now with spending is to transfer, to reconsider that express provision of the law, to consider the separate variable account as a security.
I remember the issue before when I was still in the House. nung may pumutok na scam, nagturoan nun, you were not yet there, ma'am. I don't think, how long have you been with the commission, Attorney Cabocos? Tagal.
14 years from 2003.
Hindi ko alam kung sa clown ako nandun ka na, pero nagturo ano ng IC at SEC kung sino ba talaga ang in charge at sinong sisisihin at sino ba talaga ang dapat managot on the part of government. Hence the need at that time, although it was never settled really, to delineate the role and jurisdiction of both the IC and the SEC on these matters. But anyway, Attorney Refran, sir, you wanted to say something?
Mr. Chair, thank you for having us as a resource person. Just on that point, Mr. Chair, I think the Securities Regulation Code provide for a very explicit itemization of what are considered securities, and among which is what's called an investment contract. And I think that's where the VUL, or the variable unit link, by whatever name it may be called, is a hybrid of both an insurance and an investment contract. So, interestingly enough, Republic Act 106-007, which is the revised insurance code, specifically Section 238 provides that the VUL is actually not a security. So I think that's where the policy debate is, and you raise a very valid point, Mr. Chair, because to the end investor, when you pay a premium, which is, let's say, 25% or less, and you are required to top up the next 75% because that's the structure of the VULs, then you're really intending to invest and not really to be insured. So there's two sides to that story. Whereas on the insurance company side, I think this has been since in 2010, 2011, also a way for them to manage the risk of cash flows, because this also allows them to realize investment returns because of the investment component. So, but I think from a policy perspective, even in other jurisdictions like the US, the policy question is it an investment contract? Do people pool funds, and does the investor, is an investor a passive investor, so that the expectation of profits solely, as case law would say, solely or primarily through the efforts of third parties? Is that the expectation of the investor? And we would also provide our support for that, Mr. Chair, because at the end of the day, when there are scams, as you said, like the Golden Harvest scam, this was way back, I think, more than 10 years ago, 2007, whereby there was a person who was calling proceeds in exchange for which he was saying in 30, 50 years, you will be entitled to cash flows because this represents ownership in a mango plantation. And when proceeds were not forthcoming, investors were left holding the empty bag. So the registration requirements under the SRC, when you do a public offering, Mr. Chair, because it's a securities, would be to the benefit of the investors because it's very transparent. All material information required to be disclosed. Therefore, it would inure to the best interest of the investor if it is classified also as a security, because it's an investment contract, strictly speaking. And we support very much the initiative as well, Mr. Chair, of the SEC to ensure that eventually the mutual collaboration or information sharing agreements are in place, simply because this would also allow for free flow of capital, because then we would be able to be recognized as a full-fledged member, being able to participate in the policy committees of the International Organization of Securities Commissions. And it's very much a win for us if we're able to do that, Mr. Chair. And on the other points, if the committee would be so willing, if there would be other improvements to the SRC, which we in practice have seen on a daily basis with the listed companies on the part of the brokers as well, if the committee would be willing, we would be providing for the detailed suggestions for the consideration of the Honorable Committee.
Please, sir, in relation to the bill, and help us out also insofar as coming up with a cost of regulation, meaning what additional cost would it entail a person or entity regulated with these amendments? Before I leave the issue, Attorney Cabocos, is this a question of turf, an issue of principle, or an issue of expertise or competence as to kanino dapat to? Fine, the law is there, but again, it's being reviewed now. But
Mr. Chair, no, when we look at the regulations of other countries in the ASEAN region, we look at, for example, Malaysia. Variable life is with the insurance regulator. It's the Central Bank of Malaysia,
Okay.
which is
Indonesia.
not the SEC.
Nasa ASEAN ka na rin lang naman, hindi Indonesia.
Yes, po. Kaya nga, tinitingnan po natin kung ano yung mga regulation ng other countries. In Vietnam also, Your Honor, this is also with the insurance regulator.
No, I'm asking Indonesia.
Indonesia is a super regulator, but when you check the regulator, it's the Department of the Insurance that handles the variable life. The same is true with Singapore. Singapore is also, we have the MAS of Singapore. It's actually a super regulator for securities, insurance, and banking. And when you look at the structure of the MAS, it's the insurance department that handles also the supervision of the variable life.
Under a super body.
Yes. And even if you look at, for example, Singapore, they have the collective investment scheme law, what's called collective investment code. But those products which fall under that rules, it does not include variable life. So
Sir.
basically, if you look at several countries, variable life is with the insurance regulator.
Sige nga, sir, can you submit that to us? Yung inventaryo nyo ng mga bansa na yan ang ginagawa. And if at all, also on the part of the SEC, hindi ko kayo pinagsasabong, mama. Also the countries that follow a different set of rules, placing it under the regulation of the counterpart of the SEC in other jurisdictions. One more point, ma'am. This has been bothering me for the longest time. On PDEX, is this in any way, or will this be in any way be affected by these amendments? No.
No, Your Honor. The fixed income securities use the PDEX as the platform for being able to have price transparency so that people would see all the transactions.
It is not within the definition of securities.
Fixed income securities like corporate bonds, they are securities.
They are.
But currently, the PDEX also covers government securities. So fixed incomes,
That's
two
my
kinds,
problem with PDEX, ma'am.
government securities and the corporate bonds.
That's precisely my problem with PDEX, ma'am. As you very well know, I think we had this discussion before also. I don't know if Attorney Bolivar was there. Why does PDEX, which is a private entity, why does it have a monopoly insofar as dealing with GS is concerned? So much so that foreign funds cannot access our own GS without going through a local bank who happens to be a member of PDEX. And why does PDEX have access to information that solely belongs to the national treasurer insofar as GS is concerned? And who appointed them the favorite son insofar as this is concerned? This happened during the time of GMA, so.
I think the purpose then was really to find a one platform that would cover all these fixed income securities. Because prior to that, what I understand is
private, yes,
all the
not GS.
yes, all the banks were doing all these transactions bilaterally. So there was no one setting where all the transactions could be reflected
No, but
for the
PDEX
public
is a far cry
consumption.
from the stock exchange.
Well, it's
not yet that
it's
developed.
also an SRO.
Yes, but they're not yet that developed insofar as disclosure rules are concerned. Sila rin naman yun eh. Sa totoo lang. Mama, come on. Let's call a spade a spade. Sila rin yun eh. And I understand in the beginning, siguro para mabuhay sila, I don't still understand why government had to support a private entity. Actually, partly or to a large extent owned by foreigners to deal with government securities. I don't understand that. Nung nagsisimula siguro sila, sige, para mabuhay sila, I don't even know why government had to support them so they will earn a living. Because all the incorporators are rich guys already. Pero ngayon, meron ng private securities being issued by corporations and they can very well stand on their own already.
Mr. Chairman, the private debt issuances have increased by almost 300%.
Yes, and they
the
still
past
have...
years, and yes, you're right, maybe they could still be sustainable if only covering corporate debt.
Whose decision is that? Attorney Bolivar? Is it with the DOF, the National Treasurer? How can we address that seeming anomaly? Actually, for me, ma'am, it borders on corruption, quite frankly. So not here. Not here too.
In fact, there are already moves, if you want, please, to carve out government securities from the coverage of PDEX.
Of PDEX. Moves initiated by whom, ma'am?
I think, if you want, please, it's also the banks as well as the BSP and, well, the SEC also, considering that PDEX is an SRO approved by the SEC.
As it should, and government is not even receiving a single centavo from coordinating and coercing everything through with PDEX. Correct me if I'm wrong. Wala naman tayo napapala dun eh.
Fees to SEC similar to the PSE.
By way of, because they're dealing in
Regulatory
securities.
fees, yes.
But it's actually even dampening the price of government securities,
Yeah,
if at all,
because
because it
the-
limits access to it.
Exempt.
Hindi ba? Attorney, Refran, you have a unique last name. Yes, you wanted to say something?
The PDEX is actually, Mr. Chair, classified as an exchange under the Securities Regulation Code. And I think among the securities that are traded there, GS, government securities, which are automatically listed, if there are the weekly auctions by the Bureau of Treasury.
Yes, but my problem is before the creation of PDEX, we had a running system insofar as selling government securities is concerned. All of a sudden, kailangan ilagay sa kanila.
Correct. I think that's the objection from the banks as well, Mr. Chair.
Actually, there's only one bank that's objecting.
Correct.
There's only one bank who was objecting. At that time, it was only Union Bank.
Union Bank, Mr.
Yes, all the rest simply kept quiet,
Yes.
right?
Yes. And I think the move, as Chair Herbosa mentioned, is that the Bankers Association of the Philippines will now be utilizing a system which will now carve it out of the umbrella of PDEX. In fact, the Bureau of Treasury is about to launch what's called the NRO system, which will also register the scriptless securities because GS, when they are traded of different benchmark securities, they are then registered via a registry system, and this is the registry of scriptless accounts by the Bureau of Treasury, and I think they are going to launch it within the year, end-to-end, Mr. Chair, end-to-end transaction from origination all the way to post-trade. Because right now, origination happens at Bureau of Treasury on a weekly basis. Every Monday, it does the auction, the weekly auction, and then it's automatically listed. And actually, that's the most active security in the. Maybe that will only trade on a daily basis, less than 20 trades, Mr. Chair. But if you look at the government securities, that makes up for 98% of, let's say, around 14, 15 billion pesos any given day of value traded in the fixed income exchange. No? So,
Ang point ko, kailan pa naging obligasyon ng gobyerno pakitain ng isang private organization or entity by requiring that these government issuances go through them? That's the part I don't understand, quite frankly. Ma'am, conditioned upon the submissions, we will assign this to a TWG. We invited the Stockbrokers Association of the Philippines. Are they here? They're not here. We'll invite them to the TWG. Hopefully, we can come out with a version in just one sitting, especially if the stock exchange is in support. Any comments from the BSP other than what you will submit, sir? No strong objections. Secretary is instructed to coordinate with the Stockbrokers Association so that we can get their comment. Who else should we enlist the comment and support of on this bill? Meron ba kami kailangan imbitahan sa TWG?
Mr. Chair, the other market participants,
Like who?
the investment houses, because they are also very much into the issuance of securities.
Let's invite them
EHAP,
as well.
yes.
Who in particular?
The EHAP, Mr. Chair, I'll probably get the contact person really to your staff.
Isa lang yan?
EHAP is,
Who else, Ma'am Tess? Anyone else you want to invite in the TWG? Kahit magdebate kayo doon, okay lang. At least makuha natin yung opinion nilang lahat. Yeah, we invited EHAP. Mr. Luis Gomez, but he sent his regrets. We'll invite him in the TWG. Pag hindi pa siya nagpunta, edi, sorry na lang. Who else? Anyone else you want to invite, ma'am, in TWG? So we'll have BSP, we'll have PSE, SEC. We'll send invites to the Investment Houses Association of the Philippines and the Philippine Association of Securities Brokers and Dealers. Ano to? National Association of Consumers? Ano to? Meaning the securities market? May association sila? Or are you talking consumers na bumibili? Let's also invite the BAP. And the Rural Banks Association of the Philippines, just to get their inputs, if any, on this. Anyone else, ma'am? That's it. We'll schedule TWG, if your schedules will permit, within the year bago magpasko para ma-report out namin to sa January. If not, then we'll schedule TWG at the latest within the month of January so you can report it out by February. Expect a lot of resistance, ma'am. I'm telling you already insofar as the bank secrecy exemption is concerned, because that's where we had problems. As Attorney Rosella would know, on the floor, maraming papalag palagi pagdating sa paglift ng secrecy. Hindi ako kasama dun, ma'am. In fact, I filed a bill to repeal it altogether. So we'll schedule one either within December, your schedules permitting, or at the latest January. Secretary is directed to schedule it at the soonest possible time, not later than January. So ordered. And thereafter, for it to be reported back to the mother committee for its approval and for the drafting of the committee report. So ordered. Thank you very much, ma'am. Further consideration of Senate Bill number 1595 is hereby suspended. Thank you, ma'am. Good morning. The hearing of the Committee on Banks and Financial Institutions and Currencies is hereby resumed. Let's now proceed to Senate Resolution Number 468, filed by Senators Soto and Lacson. Resolution directing the Senate Committee on Banks and Financial Institutions and Currencies to conduct an inquiry in aid of legislation into the possible violation of Republic Act Number 960 as amended. Blah, blah, blah. Anyway, this is a continuation of the hearing. May dagdag bisita ba tayo na can I ask the Secretary to acknowledge for the record our additional panelists?
Your Honor, we have additional guests from Luzon Development Bank, Mr. Jerry Auson and Attorney George Aquino. That's all, Your Honor.
Thank you. In the last hearing, if I remember correctly, NBI gave us a list of accounts that they have, which was turned over to you, if I'm not mistaken, by Mrs. Bautista, and an affidavit as well. May I get an update, ma'am? Attorney Retanal, Ma'am Minerva,
Yes, sir.
insofar as your investigation is concerned.
Sir, as far as our investigation is concerned, we have already validated some information provided by in the affidavit and some of the documents submitted to us.
Kasama doon yung mga account ng PCGG sequestered corporations na nilagay sa LDB?
Yes, sir. It was confirmed by PCGG.
It was confirmed by PCGG already.
Yes.
Chair instructs the Secretary to invite the current or sitting PCGG chair in the next hearing so that he can shed light on this. Do you confirm that, Mr. Sarmento, sir? The deposits. The existence of the deposits, not as the amounts. We have the amounts already, actually.
I think, Your Honor, we need to get a list of those mentioned accounts. So,
Can you give that? Can you give that, Attorney Retanal?
I think, Your Honor,
So if we give you a list, you'll tell us if it's an existing account or not? Mr. Sarmento? You're being advised by counsel, I'm sure.
Yes, yes, Your Honor.
Can we have your name, attorney?
Yes,
For
Your
the
Honor,
record?
I'm Attorney George Aquina, as mentioned by the Honorable Secretary.
You're being advised by counsel, so if we give you a list of those deposits and account numbers, can you confirm? Will you confirm, rather?
Existence.
Your Honor, I think it will still be covered by 1405. So unless we get a written waiver from those mentioned accounts, then perhaps we can.
These are these are accounts or deposits made by sequestered companies under PCGG's control. So, if PCGG so writes you, the current PCGG, then would you already have what you require so as not to violate 1405?
Yes, if they give the written consent. They give the
I believe so, Mr. Chairman, so long as we get a written consent of the account holders.
Again, the current, not the former, the current.
the account, proper
Yes,
representative.
because they just happen to sit there in that office at that time. They don't hold the account. It's the PCGG in theory that has control over those accounts. Would that be correct? Yes, May I proceed to Attorney Rosella? Sir, how is your investigation so far on this issue or matter? Can you give us an update before we proceed on other matters?
There are two items, Mr. Chair, that is currently under investigation. The first one is on possible violation of Luzon Development Bank. Mr. Chair, as part of due process, we have to obtain the copy of the report of examination, and we were able to get this from the Central Bank. We will transmit this to Luzon Development Bank for their appropriate reply, and then we will evaluate accordingly, Mr. Chair.
Timetable, sir?
We're looking at, because it will depend on their explanation, Mr. Chair, and the submission of their reply. So we're looking at around 2 months, Mr. Chair.
How about the BSP? Of course, you cannot divulge the results of your inquiry, correct me if I'm wrong,
Yes, Mr. Chair.
lest you be subjected to certain penalties under the MLC law.
That is correct, Mr. Chair.
Attorney Bolivar, sir?
Mr. Chair, we already forwarded the documents to the Anti-Money Laundering Council for their investigation.
And have you made any communications with Luzon Development Bank?
None, Mr. Chair.
None yet.
Mr. Chair, after the last examination of the bank, there has been no communication specific to the matters being discussed here.
Gaano katagal na yun?
The report of examination was released early this year, so we are supposed to do another round of examination next year.
And they were not. They were supposed to just keep quiet about the results of the exam. Parang kuha yan, di ba?
Mr. Chair, there are directives based on the report of examination, and after that letter to the bank was transmitted to them, the procedure is for them to reply to the directives, and the evaluation was conducted on these replies from the bank.
To reply and, if at all, comply.
Yes, Mr. Chair, there are certain directives there which require compliance. There are certain directives there which require just explanations.
At that time in January, what were the summary of the findings, if you recall?
Basically, sir, insofar as the anti-money laundering examination is concerned, it required the bank to enhance its policies and procedures for compliance with the anti-money laundering law.
Brought about by?
As a matter of procedure, Mr. Chair, our examiners do sampling of the bank's compliance with the law, and based on some sampled accounts, if we noted that there are weaknesses, we specifically identify this and direct the bank to adopt measures to correct deficiencies noted.
Sir, do you confirm receipt of that assessment or examination made by the BSP early this year?
Yes, Mr. Chairman. We have received a copy of the ROE, Mr. Chairman.
And insofar as your reply or answer to that is concerned, and compliance with the same, what is the status?
We have responded to the ROE, Mr. Chairman. I just don't have with me now a copy of the response that was made with regard to that point.
Chair would like to acknowledge the presence of Senator Grace. Good morning, ma'am. I just have one question, Attorney, Mr. Sarmiento. Is the Luzon Development Bank authorized to receive or deal with foreign currencies?
No, Mr. Chairman.
When you say no, it means you cannot receive any deposit in foreign currencies? Nor are you allowed to trade, or can you trade?
We cannot also trade, Mr. Chairman.
You cannot also trade. I raise this as an issue because I remember the interview of the brother of Chairman Bautista when he said that the monies were derived from dealings in foreign exchange. Dun daw sila kumita. He's not here. We will be inviting him in the next hearing. And it actually baffles the mind kung foreign currency exchange yung pinagkakakitaan daw nila. Ba't nila i-deposito yung pera sa inyo na hindi naman kayo authorized, if ever, mag-deal ng foreign currency? Because what's the logic in dealing in foreign currency and then converting it all back to peso again before they can deposit the money? The logic in foreign exchange dealings would be to keep it in a certain currency until such time that it's best to transfer it to another currency. Di ba? Ngayon, kung palagi mong ibabalik sa piso yung currency para ma-deposito sa bangko, it defeats the purpose. Anyway, thank you for that information. BSP confirms that they're not an authorized foreign currency trader?
They're not authorized to operate a foreign currency deposit unit, Mr. Chair,
Meaning they're not authorized
to
to
accept
receive
deposits in foreign currencies.
FCDUs? Tama?
Yes, Mr. Chair.
And why is that?
Not sure, Mr.
May
Chair, whether they
qualifications ba yun?
applied or...
Nag-apply ho ba yun? May qualification ba
It's
yun?
an authority that's supposed to be applied for by banks.
It's not given automatically. You ask for it.
Yes, Mr. Chair.
Mr. Sarmiento, sir.
Yes, Mr. Chairman. I think the bank has to ask the approval of BSP to accept FCDU accounts, Mr. Chairman.
And the qualification to receive an FCDU account or an FCD authorization would be...
There are capital requirements, Mr. Chair, and also the bank concerned should not have serious supervisory issues.
Basically, dalawang requirement lang.
Basically, Mr. Chair.
And
There are
banks know,
documentary
and banks
requirements.
know what the minimum standards are, therefore they will not apply unless they know for a fact that they can more or less qualify.
Yes,
to comply.
Mr. Chair. Part of the requirement of the BSP is for them to have an officer who will oversee the operations of the FCDU.
Senator Grace? I'll give you time to prepare. Until mag-comply sila. For the information of Senator Grace, we send an invitation upon the request of the members of the committee to Chairman Bautista. In the previous hearing that got cancelled, we were informed that he was abroad, but in the new setting, we did not receive any information as to whether or not he will attend, although our invitation was duly received in one of the addresses, known addresses he has, particularly the one in BGC.
So what will be the recommendation of the chair since he's not present today? Would we continue with this?
We will await
Questioning?
for his response, and if he does not reply, if it's the pleasure of the committee members, we can issue a request the issuance of a subpoena so that he will be compelled to attend, unless he has a valid explanation for his absence today.
Okay, Mr. Chair, I may go ahead. If I may go ahead with my questions.
Yes, Senator Grace, you may proceed.
This question is addressed to the LDB. Under Section 805 of the BSP Circular 706, all covered institutions must develop a money laundering and terrorist financing prevention program, MLPP. I would like to know how you're able to implement such program and if you've applied this in the past.
Madam Senator, I think we have our policies, procedures, and guidelines as with regard to our compliance with the AMLA regulations. And we have this in place in our bank, Madam Senator.
Mr. Sarmiento, in the past, have you actually utilized the guidelines and reported to the AMLA? I believe I asked you this before, but just please refresh our memory. You don't have to divulge at this time the depositors, but we would like to know if you actually had to invoke this.
Yes, Madam Chairman. In the past, we have reported rather covered transactions, and we have likewise filed STR, suspicious transaction reports, Madam. You just have to excuse my voice. I have bad colds, Madam Chair.
Oh, okay, sir. Well, I think it's the season. We all are going through the same harried lifestyle now. But I would like to, if you've actually utilized this, could you give me an example why you would determine an account to be suspicious?
Madam Chair, if you will allow me, I'll ask my Senior Vice President of Retail Banking. They're the ones that are on the day-to-day. They are the ones looking at this.
Okay.
Mr. Auson, you're recognized. Sir, the question is, what would qualify you to make an STR? Suspicious transaction report.
Before I answer, sir, I want to greet the chair and the vice chair. Good morning, sir. Good morning, madam. Let's say a depositor would be the the income that we believe would be higher, sorry, the deposit would be higher than the supposed the source of the income, then it could be a suspicious transaction, and it necessitates that we have to report to our AMLA, to the AMLA department.
And
or
Mr.
AMLA
Sarmiento
office.
validated, and he said that you've actually done so in the past. Am I correct?
Yes, Your Honor.
Okay. So hypothetically, suppose a depositor who has no other known source of income, especially a politically exposed person. I think our income is very public. I mean, more or less, there's a range, and you know that it would go beyond a certain range if a deposit is in a certain amount. Do you flag those? Is there a reason for you to actually suspect? Or, for example, I'm a depositor, but I have other co-depositors who perhaps have other qualified sources of income. Would you negate then reporting that particular income because there are others in that account?
If it's a joint account, and Madam Vice Chair, if there's a co-depositor and there's a document that would prove that they have other source of income, and the income would be more or less be the same as the amount deposited, then we will not report because it's
So you actually require depositors to show proof of income or sources?
we interview and we check the source of income.
So in
Your
the
Honor.
case of Chairman Bautista, he actually had to go through the interview?
Madam Vice Chair, I think it's covered by Republican Conte, so I could not confirm.
Mr. Chair.
It's what?
It's the question is specific on the depositor, so I could not confirm because I believe it's covered by Republican 1405.
If you do it, let me rephrase. Current regulations of the MLC as well as the BSP require you to find out certain details about your depositors. Is that correct?
Yes, Your Honor.
Including finding out what their source of income is,
Yes, Your Honor.
which would sometimes necessitate an interview,
Yes, Your Honor.
unless you know them already personally.
Well, even we know them personally. We are in doubt of the source of the amount of deposited, and we have to know the other source of income.
And you would interview the person.
Yes, Your Honor.
Kung saan galing yung pera, bakit ganito, bakit ganyan.
Yes, Your Honor.
Diba? So if he's a PEP, assuming may deposito ako sa inyo, he would be placed under more scrutiny,
Yes, Your Honor.
presumably.
Yes, Your Honor.
Now, to what extent will knowing the depositor personally come into play? This is actually a point of discussion between me and the MLC for quite some time when we were discussing the amendments. Because it is a known fact that when Chairman Bautista was asked why Luzon Development Bank, he said he knew the owners. I guess that's why he deposited the monies there. That was the question. Why Luzon Development Bank? He goes, because I know the owners. They're classmates of mine. I think that was the response or answer. Family friend. Now, kung family friend ng may-ari, he's still not exempted from the rule. Right?
Yes, Your Honor.
I'm presuming.
I'm not confirming about that.
Of course. But as a policy, whether kakilala personally, kababata, o kamag-anak, o kaklase ng mga may-ari, he should not be exempt from such a rule.
Yes, Your Honor. Now, he would still be categorized as a PEP. And therefore, it would be under enhanced due diligence.
Enhanced due diligence pa rin dapat siya. Now, hypothetically again, since you did not confirm and I still do not have the waiver of Chairman Bautista, anyone having more than 30 or 50 accounts under the same name or groups of name, would that as a general rule merit an SDR?
The presence of several account would not necessarily mean that it's suspicious as long as we could substantiate that.
With the permission of Senator Grace, may I ask the AMLC and the BSP, sorry, ako, ang account ko sa bangko, isa. Isa. Anyone here would roughly have one or two. My wife has 3. But simply because it's cheaper to have different bank accounts than hire an accountant para pag galing sa gantong, kunyari galing sa GMA, pasok sa account na to, galing sa Viva, pasok sa account din, at least matitrace niya. But over 30, is that, again, I'm addressing this to BSP and to AMLC, insofar as your regulations, your assessments, examination, and view is concerned. Is that normal? Ms. Karan?
Yes, po. Mr. Chair, there are no specific regulations at least issued by the BSP restricting the number of accounts a depositor may open.
How many?
There are no restrictions.
Pwede kahit ilan?
Yes, Mr. Chair. It's really up to the bank to decide whether they can allow for multiple accounts to be opened by a person.
So it's not a red flag insofar as the BSP is concerned?
Not necessarily, Mr. Chair, but it boils down to their knowing their customer better. If that customer can explain why he's maintaining several accounts and they are satisfied with the information provided to them, it's not necessarily a red flag. But if the behavior of that depositor points to something more suspicious, then they have the time to review the transactions of this depositor. And if they think that there are indeed suspicious transactions, they can cover this with a suspicious transaction report to
So
AMLC.
having numerous accounts is not per se a red flag?
No, Mr.
From the
Chair.
BSP's point of view, from the AMLAC's point of view, sir?
Mr. Chair, there are two possible extreme answers. The first is to justify such a several accounts. It's possible, Mr. Chair, that the sources of funds come in on several times, so the depositor can enter into a time deposit agreement with the bank, and then to monitor the interest rates and the income, they can open a separate account, and then all these interests can enter into that specific bank account, so several accounts. That's the first extreme answer. As to the possible violation, Mr. Chair, it could be also that these several accounts is used as a scheme to escape the covert transaction reporting. This is structuring, Mr. Chair. In such case, banks are required to file a suspicious transaction report. That's a possible scenario, Mr. Chair.
Attorney Retanal, ma'am, your findings insofar as multiple accounts are concerned?
So we agree with we considered it as a red flag, especially though we have experience, because despite the waiver issued by Mrs. Patricia Bautista, the banks invoked the bank secrecy law so that we cannot be given documents pertaining to the accounts, particularly the joint account between them. With respect to the LDB, we only have one bank account, a joint account with Mrs. Patricia Bautista.
In a joint account scenario, sir, you need the consent of all depositors?
Yes, Your Honor.
So kung tatlo sila, silang tatlo dapat?
Yes, Your Honor.
Hindi 2 out of 3?
Yes, Your Honor.
Silang tatlong lahat?
Opo.
Is that the case, Ms. Karan or Attorney Bolivar? Kailangan lahat? That's how you interpret the
Opinion,
secrecy
yes,
law?
yes, our opinion, because we are not really the expert on that. It's a criminal law, Your Honor. So that's only my opinion, yes.
No, 1405.
Yes.
How do you
Your Honor.
interpret the secrecy law? Everyone should
Yes, Your Honor. That's my
execute a waiver?
That's my interpretation, yes.
Verbal,
Both
written.
laws. Written.
Your Honor, it should be written.
Under oath?
It should just be written.
Kahit letter lang, pwede na.
Letter lang po. We will just have to verify also the signature
Eh,
verified.
siyempre naman eh. Senator Grace?
Mr. Chair, from April 2013 to 2015, Baseco opened a total 41 time deposits. I think Baseco and with LDB Pateros branch 79 and 79 time deposit accounts and one checking account with LDB Taguig branch. Also, the Independent Realty Corporation and Mid-Pasig Land Development Corporation, two more sequestered corporations of the PCGG deposited their funds in LDB. I would like to know, is it normally allowed to have funds from sequestered companies deposited with the decision alone of the chair deposited in LDB, for example? I don't know who will answer this. Is this the BSP?
Mr. Chair, our regulations require that government deposits be made only for banks which are authorized government depository banks.
So is LDB considered as one?
As to first point, Mr. Chair, is whether the nature of the deposit is a government deposit. That has to be specifically mentioned by the DOF, because the DOF issued the circular requiring all government institutions to deposit only with government depository banks.
It is
whether
covered,
they were
it is covered by the DOF circular. I read
if
the
it is
circular.
if it is a government deposit, then it has to be a government depository bank only. As to whether LDB is a government depository bank, we'll have to check.
Ma'am, there
and
are
get
only
back.
two. Di ba?
There are special cases, Mr. Chair, like when there are
Kung walang bangko doon.
municipalities,
Yes,
yes.
ma'am. But clearly,
or-
this is
yeah.
not the case here. You're only talking of land bank and DBP.
So hindi dapat
Yung
binayagan?
tuturing na government depository bank, diba? Now, there are exceptions to the rule.
There are
Kapag
special.
ka walang LDB tuloy. Kung walang land bank or DBP branch dun sa munisipyo or dun sa lugar, then they can deposit in a private bank. Di ba? That's the rule. It's as simple as that.
Generally.
Therefore, ma'am, LDB should not have had the authority to accept those deposits. Am I correct in that assumption?
We'll have to check, Mr. Chair, because in the past, there were several banks, private banks, which were granted authority to accept government deposits. And the limit there is for them to maintain their working funds only in those banks. We'll have to check and
Working
confirm.
fund and not a time deposit?
Not a time deposit.
Okay, so let me ask you now. For example, you find that the bank has violated this together with the government official that deposited in the bank. What would the penalties be?
There will be, our procedures dictate that there will be a directive for them to close that account because it violates that requirement from the DOF.
And to the bank itself, what would the penalty be?
Depending, Mr. Chair, on the other circumstances that we note in the examination. If it is a first offense, generally it's just a directive. If there is persistence, then we escalate the supervisory action. There might be reprimands or even suspension, or depending on the case, monetary penalties may also apply. We have an enforcement framework to use to determine which enforcement action will be deployed in case of violations.
I think we need to be clear about the actual penalties. Well, first, a directive that's understandable. If the bank is not consistently doing this, it could just have been neglect or oversight. But the point is, for example, in this situation, I think it's no secret, having also been exposed by his spouse, that there are several accounts, deposits that were made consistently almost every other day, just under an amount that would have been flagged by AMLA. So with all of that, and if you feel that the bank did not exercise due diligence, did not flag the account as suspicious, especially one of the depositors is a PEP, what would the penalty be to a bank such as LDB?
I'll be speaking in general terms,
In
Madam
general
Senator.
terms.
If there are persistent violations of regulations and there are inadequate action on the part of the banks concerned, the usual route of the BSP is for us to impose sanctions, like limitations in the activities that they may be allowed to do. Warning, as mentioned earlier, reprimand to the board of directors and the officers
So
involved.
reprimand meaning will they be disallowed to join other boards, other banking institutions? That should be one of them, right?
There are regulations that restrict their employment in any banking institution supervised by the Bangko Sentral.
Like
We
for
have-
example, with what happened to a bank recently, RCBC, I think they voluntarily paid a fine, right? I think they were the ones that decided, but actually if pushed further, there could have been more penalties. So it's really at the discretion of the BSP.
Yes, Madam Chair, Madam Senator, as mentioned earlier, there is an enforcement framework which we use as a guide in deploying our supervisory action.
Okay, so now my question is this. With the investigation ongoing on this suspicious accounts, whether it is admitted by LDB or not at this point, because of course there's also the bank secrecy, what's happening to those accounts? Are they still active? Are those accounts frozen? I don't know what's happening now. I mean, can they freely
Let
take
me-
money away from...
Let me answer for Luzon Development Bank because I've seen the documents and I communicated with PCGG already. All of the accounts deposited during Chairman Bautista's term as PCGG chair, insofar as sequestered corporations are concerned, have since been withdrawn from LDB as soon as his replacement was appointed. So the monies were only deposited in LDB during his incumbency as PCGG chair. As soon as napalitan siya, I don't know what year was that, when he was appointed COMELEC chair. Attorney Retanal, tama ba?
There are still accounts subsisting even after his term.
Even after his
His
So after
term.
those accounts were some of the money withdrawn, where was it, who actually withdrew it? Did they return it to the PCGG?
Nilipat sa iba. Diba?
Most probably.
Also
it was
by
transferred to
Chairman Bautista, because he's the authorized signatory?
Not really sure on that because Chairman Bautista was replaced by another appointee for the PCGG as chair.
Because he was appointed COMELEC chair.
Okay,
Yes.
so my other question is this, okay, not referring to the PCGG accounts, but the personal accounts with the siblings, are those accounts still active now, as far as you know?
We have no information on that because, as I said, the bank invoked the bank secrecy law. in the
But
matter.
clearly, at this point, we know that those accounts should have been flagged, okay? I mean, if there have been deposits every other day for this amount, and then the sources of income is unclear, at this point, there should have been a report already filed, correct? Are you in receipt of any report? Any institution, AMLAC or BSP, have you received a flagged report from LDB with regards to those accounts? With the siblings?
Madam Vice Chair, we just wanted to clarify, Madam Vice Chair, in regard to the three companies. These are SEC registered companies, Madam Vice Chair. And only Mid-Pasig Land Development Corporation is owned 99% of the Republic of the Philippines, Madam Vice Chair. The other two
Okay.
companies are still owned by private individuals, although they are in the status of sequestered companies. In such case, Madam Vice Chair, corporate powers will still be exercised by the existing board of directors.
Okay, okay. Now, if you can just, I'm not sure if this can be clarified, but there are certain accounts that received money from sequestered PCGG companies. Okay. Now, there are also some accounts that are, I don't know if I'll call this personal. Maybe Attorney Lorna can enlighten us. There are some accounts with Chairman Bautista and his siblings. Am I correct? And this has nothing to do with PCGG.
Yes, yes, Madam Senator. As a matter of fact, we have documents pointing to 34 accounts with Luzon Development Bank, only one of which is co-owned by the wife and the husband. The rest are in the name of the mother, and the other siblings.
And in those 34 accounts, at least, some of those accounts would receive regular deposits during a time period for 499,000, 500, or a little less every other day.
Madam Chair, if I may share, the chairman was in the habit of keeping records, and therefore, the wife found records of the amounts deposited, and these have been turned over to the NBI. The wife confirms now for the committee that she has executed a waiver on whatever accounts her name appears on, but the banks refuse to honor the waiver, thus hindering the investigation of the NBI.
On this point, just to advise Attorney Capunan and also perhaps Attorney Rosella, I raised this in the last hearing, but I'm not in a position to be the one to file a case. But perhaps this is a matter that the courts can clarify.
Mr.
1405 is secrecy of bank deposits. Deposit has a specific definition under the General Banking Act. There's no definition of deposit in AMLAC, diba? Deposit has a specific definition. It means an unpaid balance of money or its equivalent received by a bank in the usual course of business. So, the theory can perhaps espouse for the proper court ruling would be, pag wala ng deposito, closed account na siya eh. Secrecy of bank deposits, hindi naman sinabing secrecy of bank accounts eh. The logic of the law when it was passed, when 1405 was passed, was to encourage people to deposit their money in banks. That was the logic before, para may certain sense of secrecy and privacy para hindi matakot yung mga tao magdeposito sa bangko. It's the deposits that they were securing and not really the accounts. I will propose and I will surmise that secrecy of bank deposits does not apply to closed accounts. But of course, the banks, we had this conversation before with Mr. Sarmento, the banks will always play it safe. Diba? Meaning, why go out on a limb and say a closed account is not covered anymore by the bank secrecy law? But it's a ripe issue to be challenged before the courts, so much so that to say that secrecy of bank deposits does not cover closed accounts. Ngayon, kung manalo ka sa kasong yan, Attorney Lorna, sino mang nagtatago ng pera, mag-iwan ng 5 piso o 10 piso ngayon sa account nila para hindi pa rin mabuksan. But let that be that as it may. But insofar as
Mr. Chairman.
NBI, AMLAC, and even Attorney Capunan is concerned, you might want to bring this up. It will be in the
Precisely,
hands
Mr.
of the
Chairman.
banks.
At the chair will note that at the last Senate hearing, the banks have steadfastly used the bank secrecy law to not to proceed with inquiry on this matter. And the chair noted, or the senators noted, there were 2 exceptions. One is a possible impeachment charge, and that is done and over with, and a possible court proceeding. Because of the level of frustration of the wife, we are now prepared to file the appropriate court proceedings regardless of how the ongoing investigations are proceeding based on personal knowledge and documents found by the wife herself.
Mr.
Actually,
Chair.
ma'am, while you're at it, sorry, just on that point, while you're at it, total naman, akit na rin kayo sa korte. Maganda rin matanong, are impeachment cases really considered moot and academic simply because the person resigned? Because quite frankly, impeachment carries with it the penalty of absolute perpetual disqualification to hold public office. The objection of impeachment is not only to remove a person from office, it is actually also to forever bar him or her from holding any other office or post in government. So mere resignation does not necessarily render such a case moot, but then again, that is up to the House and not up to us. We will try whoever is impeached by the House, but it's not up to us. Senator Grace, sorry.
Attorney, if you file a case and you win and the courts direct them to open those accounts, that would be a long route to take. Okay, it can take years for that to even happen. But if LDB, for example, my question is this: if they flag those accounts already now as suspicious, and they themselves file a suspicious account report, I don't know what it is, then that in itself might speed up the process because number one, they have the authority to put those accounts on hold, right? And no activity can take place. Do they have that power to do that if they flag an account suspicious, BSP? For example, ako yung may-ari ng bangko or ako yung sa board, and I find, wow, this account, I'm not sure what the source of income is here, so I will flag this as a suspicious account. Does the law give them the right to freeze that account pending an investigation?
There's none, Your Honor. There
So-
are only cases under the AMLA law where the account can be put in.
Oh, AMLA. So, hindi nila pwedeng itigil yung transaction dun sa account na yun. Pwede pa rin magdeposito, pwede pa rin mag-withdraw ang mga account holders.
Madam Vice Chair, under the law, it is only the Court of Appeals or the Council that can issue freeze orders.
So, meaning AMLA. Council
In certain cases, Madam Vice Chair, for kidnapping for ransom, drug
Terrorism.
trafficking and terrorism, it is the council that can issue those kinds of orders.
So, not
For
this
all
type,
other
not for
cases,
corruption or...
Court of Appeals. No, Madam Vice Chair, but there are also cases where the bank itself, based on their internal policy, they can also hold but not freeze, Madam Vice Chair.
They can hold. What's the difference? They can.
That's based on their internal policy. For instances where they think the transaction will affect their business operations, they can on their own, based on their sound judgment, hold the withdrawals or.
So they can do that.
transactions. Yes.
Okay.
Madam.
So I guess my question now, because I think LDB won't answer it, and of course we understand also that the banks will have to protect its reputation, keeping sacred the deposits in their trust. But did they already report to you those suspicious accounts that we've been discussing? At least did they file any recently? The accounts that have been flagged
Madam Vice Chair, with
under the PEP.
Yeah, with all due respect, Madam Chair, we are obligated under the law not to divulge the fact that an STR or a covered transaction report is filed.
Even filed, not even the details, just filed.
Yes, Madam Chair, that is part of the confidentiality of reporting covered transactions and suspicious transactions. The objective of this provision, Madam Vice Chair, is to encourage covered persons such as banks to file these kinds of reports and not to put harassment on certain individuals.
Okay, so I guess my question now will be hypothetical. Okay. Considering all of these proceedings that we've had, everything that's been discussed, if in the future a case is filed in court and the court allows those accounts to be exposed, based on what you're seeing now, for example, would you say that if the bank did not file a report to you of a suspicious account, then that would warrant them being in connivance or perhaps not complying with regulations?
Theoretically, Madam Vice Chair, what the Council Secretariat will do is to gather enough evidence to establish
Ganito na lang, sir, kunyari, okay. So, pinag-uusapan na natin to, hindi naman kami naglabas nito eh, yung mismong kabiyak niya. Okay. May mga account, sabihin na natin iba, wag ito. Kunyari, may isang tao nagde-deposit, ang kinikita lamang 100,000 sa isang buwan. May mga kapatid na kasama na siguro may ibang sources of income pero merong PEP na kasama doon. Alam mo ito lang. Tapos every other day, 34 accounts, iba-iba, may deposit. Would you say that that should prompt the bank to immediately file for a a flagged account? Hindi na ito kahit lang sino. Basta, kunyari kami, PEP kami.
Madam Vice Chair, there are 6 circumstances for filing a suspicious
Please
transaction
enlighten
report.
us.
The first circumstance to which it is, we think is very pertinent is structuring. Structuring happens when a depositor, in order to avoid, and I highlight this phrase, Madam Vice Chair, in order to avoid being a subject of a covered transaction report, will structure the deposits. In the interpretation of this provision, Madam Vice Chair, is covered transaction reports are filed by banks when the transaction exceeds 500,000 pesos. So for a 1 million deposit, they would structure this and divide this transaction into 2, deposit it by 500,000 twice. This will not be covered by any report, covered transaction reports. So this is the example of structuring.
We've seen already that it falls under this, just with that first category. Second, what's your second category?
Deviation from the profile of the customer, Madam Vice Chair. Customers or covered persons are mandated to risk profile the customers. And if the customer is a PEP, naturally the source of funds would come from the salaries they receive from the government. So if one of the minimum requirement is the source of funds, and if they specified that their sole source of funds is government salary, then if they deposit or make a transaction in excess of such source of funds, that will fall within that circumstance, which is deviation from the profile of the customer. And third, Madam Vice Chair, is when the transaction is not commensurate with the business. This is somewhat related to the second example, Madam Vice Chair. Here, the business profile of the customer is assessed by the covered person. And when the transaction itself is no longer commensurate with the business profile, then another circumstance for filing a suspicious transaction report can occur. The fourth circumstance is when the transaction is related to an unlawful activity. So unlawful activities, there are 34 unlawful activities, one of which is plunder, graft and corruption, the second, and other related predicate offenses, Madam Chair. If the transaction is related to those unlawful activities, then the covered persons are mandated to file a suspicious transaction report. Fifth is when the client is not properly identified. So, for example, the customer submits a fake ID, that will fall under that circumstance. And the last one, Madam Chair, when the transaction is without legal justification. So, when probably, for instance, when the cashier asks for the source of funds and the depositor would reply nothing, so that's without justification, then a covered person can file a suspicious transaction based on that circumstance.
Certainly, if a depositor comprises 10% of the bank's deposits, the bank should certainly know about that client. Probably that client would be very familiar, so they would know they should know at least a source of income. Am I correct?
Part of the risk management of banks, Madam Chair, and I believe this is very normal for banks. They would have or require their officers to submit liquidity reports on a daily or regular basis. So, sourcing part of their liquidity report would have to assess the liquidity requirements of their banks on a regular basis. And having one depositor control certain percentage of their deposits or liquidity should have a corresponding control mechanism, because it exposes banks to concentration risk, Madam Chair.
Thank you, sir. Actually, Attorney Lorna, those companies that's actually quite a strong point you made here. And no, I mean, if you have hundreds of thousands even of depositors, but if one can spell the difference for whether your bank will be tomorrow liquid or not, I mean, you should be able to really understand the business of that depositor. Attorney Lorna, for example, these companies of the siblings of Chairman Andy, do they even file taxes for the earnings of their company? Do they have that? Did they present that?
Madam Vice Chair, in fact, we inquired into that, and on national TV, the brother, when interviewed, said that he and his siblings did not file their own tax returns because they entrusted that to their brother, Chairman Andy Bautista.
So did Chairman file?
I think there has been a directive to the BIR to make inquiries into whether the appropriate tax filings were made or taxes paid.
Because it would be evasion, right? If all those income has been coming in without the corresponding taxes paid on those.
Yes, Madam Senator, also on national TV, the brother, Martin, admitted that the source of the income was not from his brother, allegedly, but from his own professional fees in some rinky-dink town in the U.S.
Is he a citizen of the Philippines, or is he a dual citizen? What is he?
He claims to be both, Madam.
Okay, because that in itself,
the fact that he ran for senator of the republic,
he should have renounced. So now,
renounced. But he's saying that his income is not from the Philippines; it is from his practice in the U.S.
Okay, that alone, I think the bank is required now with the international banking community, particularly the U.S., that if you have a citizen of the U.S. with a bank account in the Philippines, they're supposed to report that, right?
Yes, Madam Chair, especially since the joint accounts are mostly in the name of the brother, the mother, and the sister, with only one account being co-owned or in the name of both the husband and the wife.
So that in alone, the bank may not be compliant with the banking standards. For example, because I know that you have to sign a waiver that if you're I think in any country now, you have to sign a waiver if you're a citizen of another country, because a certain report protocol has to be done. And I wonder, do you do that for your foreign depositors?
We report foreign...
Sir, the mic, please.
Sorry, Your Honor.
It's okay, sir.
We report transactions of foreign depositors.
Okay, so perhaps they should eventually show that they did report those for... Okay.
With the permission of Senator Grace, there is a new requirement or regulation issued by the IRS requiring all U.S. nationals, even those holding dual citizenship status, having dual citizenship status, to submit an inventory of all their assets wherever it may be. So, sino mang dual citizen na Pinoy na may bank deposits dito, they're required to literally write the bank account and name of the bank in that form. and declare it in the U.S. Now, Attorney Lorna said earlier na babayaran ni Chairman Bautista in tax if it's a corporation, but if it's an individual, and I presume the accounts are individually held, not by a corporation.
Mr. Chairman, the actual statement of Martin on national TV was he does not know whether there are filings being made. He doesn't know if taxes are being made because his brother, Chairman Andy, is in charge of all of this.
He's required to make to file from wherever the income may come from if he's a Filipino citizen. Kahit galing Amerika, yung kinikita niyang pera, kailangan pa rin niya magbayad ng buwis dito. Especially if the tax rates there are lower than the tax rates here. He has to pay the differential. Yan yung kaso nga ni Pacquiao, di ba? Naalala niyo, sinampahan po siya ng kaso na nasa CTA ngayon. Yung kinita niya sa Amerika, kinlaim ni Kim Inares no, na hindi raw binayaran. May naman yun eh. Sa pagkinita mo galing doon, kailangan mo pa rin magbayad dito. Unless you present proof that what you paid there is higher than what you're supposed to pay here. Now, if there's a differential, then that's what you should pay here. Because we have a treaty on double taxation with the United States. On Attorney Marcela, the six circumstances you mentioned, Attorney Kapunan, bear with me. Again, I don't want to belabor the point with Luzon Development Bank. Their hands are tied. Dun sa anim mong binanggit, based on the admissions of the brother of Chairman Bautista and Chairman Bautista himself, it should have merited an STR, except for the fake ID part. 1 to 4 and number 6 would have been clearly included. The first one, you had said, a scheme. When asked about regular deposits of every other day, some daily of below 500,000 and the amounts of 400, 420, 430, ang sagot ni Chairman Bautista, although it was not under oath, was may binili raw na condominium sa kanya si Attorney Divina, kaya hinuhulog-hulugan sa kanya. Maniniwala akong hulog-hulog yun kung buwanan. Wala pa akong nakitang naghulog sa condominium na below 500,000 na every other day. So it would fall under. Again, I'm basing it on his admissions. So that would fall under the first circumstance requiring an STR. Second, salary or business hindi commensurate. Again, the brother said that, Martin said that they entrusted the family's money in business at yung kinita niya na $1 million na hindi naman daw malaking pera, normal lang daw sa kanila yun, sa kanyang kapatid na nasa gobyerno. Now, I have seen government officials, congressmen, senators, whoever, giving money to their sister or brother for them to invest. This is quite frankly the first time I see a situation wherein yung mga kapatid na nasa pribadong sektor ang nag-invest sa kapatid nilang nasa gobyerno. As if he has so much time to invest the money, find out what the good investments are on top of what he's doing as full-time COMELEC chair. That would clearly fall under your second circumstance as well. Insofar as the third circumstance is concerned that you mentioned, well, they also admitted that the money came from their dealings in foreign currency. And as admitted earlier, the Luzon Development Bank is not an authorized foreign currency trader. So when it's finally opened, I hope LDB can tell us what admission they gave them. Saan galing yung pera? But by their own admission, sabi nila, galing daw sa foreign currency trading yung perang kinita nila. Nung nakita ko ang ganun kalaki pala yung kinikita sa foreign currency trading, pinag-aralan ko rin yun. Hindi kaya eh. Hindi ko kayang kitain yung ganun kalaki, maliban na lang kung yung puhunan mo to begin with, sobrang laki. At paano kakikita ko, ibabalik mo ulit sa piso, yung pinagkakitaan mo sa foreign currency trading, it simply defies logic. You mentioned anti-graft, there are allegations to that effect. Made by the wife and it's under investigation by the NBI now. Again, except for the fake ID part, it would seem that based on their own admissions, it should qualify, it should require an SDR. I just wanted that for the record. And until Chairman Bautista appears and clarifies, and they have said on national TV with much braggadocio that they will appear and defend themselves, I hope they will heed their own words that they made a couple of weeks ago. So the committee will be sending an invitation to Mr. Martin Bautista for him to attend the next scheduled hearing, and we will be requesting the Senate President to issue a subpoena to Chair Bautista, given the fact that he did not even give us a reason for his absence in this morning's hearing.
Mr. Chairman, the bank
Yes.
accounts and the NBI confirms, are also in the name of the mother and the sister?
For the meantime, because I can secure hopefully their waivers, insofar as these accounts are concerned. I'm giving due consideration to the mother, who may be already of late age. Ilang taon na, Ms.?
That's the sad part, Mr. Chair. She's already in her late 80s, and to have used her for this dubious accounts really is unfortunate.
I will consider it, but for now, I would like to spare her from this inquiry. We would also like to issue an invitation to BIR insofar as their findings insofar as the request or payment of payment or non-payment of taxes is concerned. Sino pa? Lawrence, sino pa?
He also got involved with securities, and the NBI also confirms that there are two other bank accounts involved, BDO and Hong Kong, Shanghai.
May secrecy of bank deposit ba sa stocks?
RCBC.
Hindi. Wala, di ba?
Mr. Chair, deposits and investments are the ones mentioned in R.A. 1405. So, deposits and investments.
Through banks?
I'm not sure if stocks will.
Through
Yes.
banks?
Yes, sir.
If he invested through a bank, that's correct. But if you buy shares of stock through a broker, is that covered? I don't think so. Yes, Attorney Reteral?
We also, excuse me, Mr. Chair, we also summoned the securities. Some of them complied, some of
Sino
them
securities?
invoked. Those with PCCI, De Castro Securities,
I am brokers niya.
brokers, yes, sir.
I don't think they're covered. I don't think they're covered
But
by
some
the
of
bank's
them,
secrecy.
some of them are affiliated with the bank.
Well, those who are affiliated with the bank, I presume, may be covered, but those who are not covered.
But mostly, they are affiliated with the bank, Your Honor. Mr. Chair. So they also invoked, well, some of them invoked data privacy, confidentiality.
Chair
and
also
1405.
instructs the committee secretary to kindly obtain a copy and request from relevant agencies a copy of the SAL-N of Chairman Bautista so that we can compare it with whatever admissions he will make or whatever documents we have obtained thus far. Any other points?
RCBC and HSBC.
My problem, Attorney Capunan, is even if you invite the other banks, they'll say exactly what Mr. Sarmiento is saying, and they will be well within their rights to do so. So I'd rather await for the subpoena to be served on Chairman Bautista unless he voluntarily attends, and hopefully he will make true his word to so execute a waiver and to allow a full investigation and inquiry to proceed.
Thank you, Mr. Chair.
But Mr. Chair, if he executes his waiver, but the other
Do not.
account holders don't,
I will consider this lookout. How can it be fully investigated when he does not secure the waiver of his co-depositors? And since they entrusted him with that money, I presume they will entrust him too when he signs a waiver for them to follow suit and sign a waiver as well. Again, just to avoid any liabilities on the part especially of Luzon Development Bank or the other banks. They need a way out too, until we repeal the bank secrecy law, hopefully, with Attorney Rosella. But until that time comes, I understand where LDB is coming from. We cannot force them, and we should not force them to violate existing law until it is repealed. Anyone else you want to invite? Sabay nag-isip. Hindi birthday party to, ah. We'll schedule the hearing sometime mid to third week of January to afford enough time and to serve notice to Chairman Bautista. Maybe enlist the help of Attorney Capunan, because when we last sent the invite for this hearing, we sent it to 3 different addresses and it was only received properly in one address. In the previous address that received our invitation, hindi na tinanggap this time around. So, I don't know what's going on, quite frankly. But if you have any information that you can share with the committee, kindly help us serve the notices, if at all, and or subpoena.
Yes,
Also
Mr. Chair.
to the brother. Any other points you want to raise, Mr. Sarmiento? Going. Attorney Aquino, you want to say anything? There being no further matters to be taken up, and while we are awaiting the attendance of certain witnesses, hearing is in the meantime suspended, and further deliberation on PS Resolution number 468 is likewise suspended. So ordered. Hearing is suspended. Thank you for attending this morning's hearing. Salamat po sa panahon at pasensya na sa abala.